Legal and Privacy Brief for June 16, 2026. The Trump administration used export controls to force Anthropic to shut down its Fable 5 and Mythos 5 AI models with no due process, marking the first time export controls reached deployed AI services. Supreme Court granted review on whether Florida's 6-person juries violate the Sixth Amendment, and when immigration detention requires a bond hearing. UK announces a ban on social media for children under 16, going further than Australia's model with age assurance requirements and restricted live streaming. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief June 16, 2026. Next section, Enforcement Actions. Trump DOJ, the Department of Justice, approves $111 billion Paramount Warner Bros. Merger. The Department of Justice approved the $111 billion Paramount Warner Bros. Merger, backed by Saudi and Chinese funding, after a Friday news dump. The DOJ's Antitrust Division claims the deal will increase competition by offering consumers a more robust competitive alternative to the larger SVOD offerings. Despite Warner Bros.' history of acquisition-related mass layoffs and price increases, the DOJ acknowledged Warner Bros. Has been a repeated acquisition target in the media and entertainment industry, and cited investigations of AOL/Time Warner, 2001, AT&T/Time Warner, 2018, and Warner Bros./Discovery, 2022, all involving challenges that arise when the commercial rationale for a deal lacks clear alignment with competitive incentives. Paramount's top lawyer Makan Delrahim served as Trump's DOJ enforcer during the first administration and personally approved the Sprint T-Mobile merger. Compliance action. Media companies subject to FTC, the Federal Trade Commission, or DOJ antitrust review should document competitive effects and market concentration analyses before announcing mergers, particularly deals involving entities with prior enforcement actions. Sources: TechDirt. California Attorney General Enforcement. Implied activity. California AG is listed as a priority enforcement feed monitoring agency actions, but no specific enforcement actions were reported in today's articles. The feed's priority status reflects its role in state-level privacy and consumer protection enforcement. Source: feed metadata. Next section, Litigation Updates. Supreme Court to review Florida 6-person jury constitutionality. Cayenne case. The Supreme Court agreed to hear Hamed Cayenne's challenge to Florida's use of 6-person juries in criminal cases. Cayenne was convicted by a 6-person jury of 5 counts of practicing chiropractic medicine with a suspended license and sentenced to 1 year and 1 day in prison. He argues the court should overrule Williams v. Florida 1970, which held 6-person juries do not violate the Constitution. Cayenne contends that Ramos v. Louisiana 2020 rejected the cost-benefit analysis Williams relied on and returned to the original meaning of the Sixth Amendment right to trial by jury when it was adopted. Compliance action. Employers with Florida operations should review criminal referral policies and consider how jury size requirements might affect conviction standards in employee misconduct cases. Source: Scadu S. blog. Supreme Court to review immigration detention bond hearings. Genelo v. Black, the court granted review on whether non-citizens held in prolonged immigration detention have a constitutional right to a bond hearing and whether the government must justify continued detention by clear and convincing evidence. The case involves KZGM, green card holder detained 21 months after an assault conviction. The Second Circuit ruled that when detention becomes unreasonably prolonged, the government must hold a bond hearing to determine flight risk or danger to the community. The Trump administration appealed, noting that Jennings v. Rodriguez, 2018, rejected statutory entitlement to periodic hearings but did not resolve the constitutional questions. The court directed litigants to brief whether the case is moot because GM was released from custody in 2022. Compliance action. Employers with foreign national employees should document criminal case outcomes and immigration status to anticipate potential detention scenarios and consult immigration counsel on bond hearing rights. Source: Scadu S. blog. $2,995 M. Tuft and Needle deceptive discounts. Class action settlement consumers can receive 45% of the discount they received on mattress purchases from a $2,995 million Tuft and Needle settlement, resolving claims of deceptive discount practices. The settlement addresses allegations that advertised discounts were misleading or inflated. Compliance action. E-commerce operators should audit discount claims and promotional pricing to ensure compliance with state consumer protection statutes prohibiting deceptive pricing, particularly reference pricing and with /now comparisons. Source: Top class actions. $2 Bestway spa pump defect class action settlement. Bestway agreed to a class action settlement resolving claims that certain Bestway spa pumps are defective and can cause fires. The settlement provides compensation to class members who purchased the allegedly defective pumps. Compliance action. Product manufacturers should review safety testing protocols and failure mode analysis for electrical devices, particularly those involving heating elements or motors operating near water. Source: top class actions. $725 Facebook privacy class action settlement issues bonus payments. A second round of payments went out in the $725 million Facebook privacy class action settlement nearly a year after the first distribution. Eligible claimants received bonus checks from residual settlement funds not distributed in the initial round. Source: top class actions. Johnson & Johnson wins talc bellwether trial over ovarian cancer, claims a Los Angeles jury found Johnson & Johnson and Red River Talc not liable in a bellwether trial involving claims that talcum powder products caused 3 women to develop ovarian cancer. The defense verdict provides J&J with momentum in ongoing talc litigation, but does not resolve the thousands of pending claims. Source: top class actions. Covidien faces hernia mesh bellwether trial. A federal judge cleared the way for a bellwether trial in a Medtronic hernia mesh lawsuit, alleging that subsidiary Covidien misled physicians about a critical safety feature of its Symbotex composite mesh device. The trial will address claims that the mesh's barrier layer degrades too quickly. Source: top class actions. Federal judge blocks Trump National Parks display removal order. Massachusetts federal judge Angel Kelly ordered the Trump administration to reinstall displays removed from national park sites under an executive order targeting diversity, equity and inclusion day, content and climate change information. The court found the removals set a dangerous precedent of censorship and sanitization while undermining the integrity of the national park system. The court ruled the executive order violates laws governing the National Park Service and congressional oversight, and fails to justify itself by serving the public interest. Examples of censored content include exhibits memorializing people enslaved by George Washington at Independence National Historical Park in Philadelphia, signage detailing climate threats at Fort Sumter in South Carolina, and signs involving slavery, abolition, immigration, labor, women's suffrage, and civil rights. Compliance action. Federal contractors and grantees should preserve documentation of DEI programs and climate-related content in anticipation of potential executive order conflicts with statutory mandates or contractual obligations. Sources: TechDirt. Next section, regulatory guidance. Trump export controls force Anthropic to shut down Fable 5 and Mythos 5 AI models. The Trump administration used export controls to force Anthropic to shut down access to its Fable 5 and Mythos 5 AI models with no due process, marking the first time export controls have been enforced to control access to a deployed AI model. The government claimed that for national security reasons, no foreign national could access the models, including Anthropic's own foreign national employees. Since Anthropic cannot determine which customers are foreign nationals, the company shut down all access. The trigger was a jailbreak, and Amazon, one of Anthropic's largest investors, tipped off the government. Fable 5 was available to any commercial subscriber, while Mythos 5 was limited to pre-vetted organizations. Anthropic's latest models required enterprises to accept 30-day data retention for safety reviews, departing from previous zero retention policies. Compliance action. AI companies and cloud service providers should audit foreign national access controls, implement nationality verification systems, and prepare contingency plans for emergency model shutdowns under export control orders. Enterprise customers should review data retention policies in AI vendor agreements. Sources: TechDirt Lawfare. UK social media ban for children under 16, announced. UK Prime Minister Keir Starmer announced the government intends to block youth under age 16 from using social media with what it calls the strongest kids' online safety measures in the world. The ban will apply to user-to-user platforms including TikTok, Facebook, Instagram, Snapchat, X, and YouTube, but not messaging platforms like WhatsApp. AI romantic companion chatbots and intimate functionalities will be restricted for children under 18. The government plans to pass legislation before Christmas, with enforcement by spring 2027. The UK model goes further than Australia's December 2024 ban by requiring highly effective age assurance methods, blocking harmful functions like live streaming and stranger communication with children under 16, possible overnight curfews, and required breaks in infinite scrolling for teens under 18. The UK's communications regulator must design age assurance measures and report back by October. 9 in 10 of 116,000 parents surveyed backed the ban. Australia's ban has not kept large numbers of youth off platforms, with 31.3% of previously active children still maintaining accounts after the ban took effect, primarily because tech firms had not asked them to verify their age. Compliance action. Social media platforms, gaming sites, and online services with UK users must prepare age verification systems and content restriction mechanisms by spring 2027. U.S. companies should monitor similar legislative efforts in Spain. Under 16 ban announced February 2026, Netherlands, under 14 ban proposed, and France, legislation in progress. Source: The Record. Supreme Court Emergency Docket. Texas App Store Age Verification Law, SB 2000-420, students engaged in advancing Texas, and the Computer and Communications Industry Association asked the Supreme Court to restore orders blocking Texas from enforcing SB 2000-420, the Texas App Store Accountability Act, which imposes age verification and parental consent requirements on minors' access to apps and paid content. U.S. District Judge Robert Pittman temporarily blocked the law in December 2025, but the Fifth Circuit put the block on hold June 4, 2026. Students argued the Fifth Circuit's decision would render virtually the entire internet, not to mention the distribution of every book, newspaper, magazine, movie, or record album, commercial speech the government could more readily ban, restrict, edit, or compel. The CCA argued the decision has upset the status quo by allowing the act to be enforced for the first time, exposing app stores and millions of app developers to potential liability, and subjecting them to enormous and unrecoverable compliance costs. Justice Alito instructed Texas to respond by 4 p.m. EDT June 22, 2026. Half the states have similar age verification requirements for minors. Compliance action. App developers and app store operators should prepare age verification compliance frameworks for state laws pending Supreme Court resolution of SB 2000-420. Monitor the June 22 Texas response deadline and subsequent Supreme Court action. Source: SCOTUS blog. Counter UAS authority gap for National Guard personnel. Title 32 vs. Title 10. A gap in statutory authorization prevents National Guard personnel from protecting military installations in the U.S. from unmanned aircraft incursions when acting under state control and Title 32, even though they have authority when federalized under Title 10. These sites support federal missions and host Department of Defense equipment, and are often secured by National Guard personnel operating in Title 32 status. The same individual, standing in the same place, confronting the same threat, may be unable to act based solely on whether or not they're federalized. Compliance action. Defense contractors and critical infrastructure operators near military installations should coordinate drone detection and countermeasure programs with installation security offices and clarify which personnel have counter-UAS authority under current statutes. Source: Lawfare. Next section, privacy developments. Maine closes data breach portal. After fake reports, Maine closed its widely used data breach reporting portal to the public after 2 fake breach notices were posted. One bogus notice appeared Thursday, claiming 2.4 million VR chat customers were breached on fake VR chat letterhead. Fake Discord breach notice was also posted. Maine will still allow companies to report breaches, but will not make the portal easily available to the public until it completes an audit of procedures to stop such incidents. Members of the public can contact the Attorney General's office to inquire about existing reports. The portal was easy to abuse, historically allowing companies to add notices without review. VR Chat stated the fake notice remained up for several hours despite requests for removal. The Maine portal has been a valuable resource for security researchers, reporters, and threat intelligence companies. Compliance action. Companies relying on Maine's breach portal for threat intelligence should implement alternative monitoring using California AG breach reports, state-specific portals, and commercial breach databases. Organizations should verify breach notices through direct company contact before acting on threat intelligence. Source: The Record. FACTA Credit Card Information Exposure Investigation Top Class Actions is investigating potential FACTA violations where paper receipts displayed too much credit or debit card information. The Fair and Accurate Credit Transactions Act, FACTA, limits the credit card information retailers can display on receipts to prevent identity theft. Compliance action. Retailers should audit point-of-sale systems to ensure receipts truncate card numbers to the last 5 digits and do not display expiration dates, as required by 15 U.S.C. 1681 CG. Private right of action allows statutory damages of $100 to $1,000 per violation. Source: Top Class Actions. Next section, policy changes. Lilly Ledbetter Fair Pay Act. The dissent that became a statute Scadu S blog published a retrospective on Leadbetter v. Goodyear Tire and Rubber Co., 2007, where Justice Ruth Bader Ginsburg's dissent inspired Congress to pass the Lilly Ledbetter Fair Pay Act of 2009 without delay. The Supreme Court ruled 5-4 that Ledbetter's pay discrimination claims were time-barred because the limitations period began when the discriminatory pay decision was first made, not when each paycheck was issued. Ledbetter, a supervisor at a Goodyear, Alabama plant for nearly 20 years, was paid $3,727 per month, while male counterparts earned $4,286 to $5,236. She only learned of the disparity through an anonymous note. A jury awarded her $3.5 million, reduced to $360,000 by statutory caps, but the 11th Circuit overturned the award. Justice Alito's majority opinion held the 180-day limitations period under Title Roman VII of the Civil Rights Act of 1964 began when the pay decision was made, not when paychecks reflecting that decision were received. Ginsburg's dissent argued pay discrimination is inherently cumulative, and the statute should be read to allow claims based on the continuing effects of past discrimination. Compliance action. Employers should conduct regular pay equity audits comparing compensation by gender, race, and protected class within job categories to identify and correct disparities before they compound over time. Document legitimate business justifications for pay differentials. Source: Scadu S blog. Appeals Court allows 10% worldwide tariffs to continue during challenges. The U.S. Court of Appeals for the Federal Circuit ruled Thursday that the Trump administration can continue collecting the 10% worldwide tariff imposed in February while challenges work through the courts. The Supreme Court struck down tariffs imposed under a different authority. Challengers contend the administration lacked authority to impose the tariffs under Section 122 of the Trade Act of 1974, which addresses fundamental international payments problems, not trade deficits as the administration asserts. A split three-judge panel of the Court of International Trade found the 10% global tariffs illegal, but the Federal Circuit put that decision on hold. The Section 122 tariffs are set to expire July 24, 2026. Compliance action. Importers should continue paying the 10% tariff under protest and preserve refund claims pending final court resolution. Monitor the July 24 expiration deadline for potential renewal or replacement tariff programs. Source: Scadu S blog. Fifth Circuit ICE detention, ruling bypassed by constitutional due process, claims the Fifth Circuit ruled in February that ICE can detain without bond thousands of immigrants with established roots in the U.S. But judges bound by that ruling have overwhelmingly continued to reject ICE's detention policy by concluding ICE violated detainees' constitutional due process rights, a distinct violation the appeals court did not address. Federal courts of appeals have split over ICE's detention policy, putting the issue on a likely path to the Supreme Court. Compliance action. Employers sponsoring foreign workers should track detention policy developments and advise employees of due process hearing rights if detained by ICE pending removal proceedings. Source: Scadu S blog. Next section: Compliance takeaways. Social media age restrictions. Prepare age verification systems for the UK's spring 2027 enforcement deadline under 16 ban and monitor similar legislative efforts in Spain, Netherlands, and France. Half of U.S. states already have age verification requirements for minors. AI export controls. AI companies and cloud service providers should implement foreign national access controls and nationality verification systems following the Trump administration's use of export controls to force Anthropic to shut down Fable 5 and Mythos 5 models with no due process. State breach portal disruption. The closure of Maine's public data breach portal, after fake reports, requires companies to implement alternative threat intelligence monitoring using California AG reports, state-specific portals, and commercial databases. Pay equity audits. Conduct regular compensation audits comparing pay by gender, race, and protected class within job categories to identify and correct disparities before they compound over time, per the Lilly Ledbetter retrospective. Point-of-sale receipt compliance. Retailers should audit POS systems to ensure receipts truncate card numbers to the last 5 digits and do not display expiration dates under FACTA 15 U.S.C. 1681 CG, which allows statutory damages of $100 to $1,000 per violation. Immigration detention policy. Employers with foreign national employees should document criminal case outcomes and immigration status to anticipate detention scenarios and consult Immigration Counsel on bond hearing rights as courts split on ICE detention policy heading toward Supreme Court review. That concludes today's legal and privacy brief. from Carolina Clear Tech, for informational purposes only, not legal advice.